Hi, my name is Jordan Rodney. I'm the founder of Rodney Employment Law, an employment law boutique firm specializing in all workplace issues. Today I'm here to talk about a very critical topic that almost all employers face in Ontario: accommodation. It's difficult, it's delicate, and there's a lot of tips that employers need to know as they work through this very challenging topic. The first thing is the legal duty to accommodate. In Ontario, under the Human Rights Code, it expressly prohibits discrimination and harassment in the workplace. And harassment and discrimination occur when there's a violation of the prohibited grounds of discrimination. These are things like age, marital status, gender, sexual orientation, and disability. And disability can be very broad. It can be physical disability, mental health issues, or other types of disability. That's an area that continues to grow and be challenged for employers. The other thing to keep in mind with the legal duty to accommodate is there's both a procedural and a substantive element. The procedural element says that an employer needs to, quote, turn their mind to accommodation and can't simply say, we're too small, we can't accommodate, we don't have the money. You have to go through a procedural analysis and come up with a substantive outcome. And that's something that the Supreme Court has said repeatedly needs to be in place. The second thing I want to talk about is the duty to inquire. When an employee is not able to come forward and discuss their human rights issue, the question is, was the employer aware, or ought they have been aware, of the employee's health issue, thus prompting the duty to inquire. So in cases where an employee might not be comfortable coming forward, an employer has a mandatory legal duty to ask those difficult questions. And one might argue, how is an employer supposed to know? And what I would say to employers is keep your antenna up and make sure you notice, is there a deteriorating performance? Do you notice your employees being abrupt or losing control or maybe having anger management issues or missing work? There are certain signs that you need to be aware of as an employer that would trigger this duty to inquire. The next thing is assessing the need for accommodation. And the most important thing, if an employee says, I want to be accommodated, that doesn't necessarily lead to accommodation. Accommodation is to be done on a case-by-case, fact-based approach. And an employee has an equal role to the employer as coming up with options for accommodation. Accommodation needs to be practical, it needs to be viable. And it's very critical that employers do not take a cookie-cutter approach when it comes to accommodation. And you need to look at, as I said, each case on a case-by-case approach. It's not something that can be prescribed, but it needs to be dealt with as it comes up. And there's all sorts of accommodation that even might not be anticipated in your workplace with some of the new expanded definitions of disability, the rise of, in the last couple of years, the transgendered and the transgender community. There's a lot of things that 10, 15 years ago, employers didn't really have to think about. So it's about being creative, being open-minded, and being fact-based. Next, I want to talk about the limits to accommodation. Accommodation is not limitless and infinite. Accommodation, it does have limits, and the legal test is something called undue hardship. So what the courts have said repeatedly is undue hardship involves some inconvenience, involves some difficulty and some challenges for employers, and they need to go through a process to reach undue hardship. The factors that you need to look at are as follows. What are the safety concerns? What is the impact on other employees? What is the size of the operation? What are the financial consequences? So as an example, a small family-run company would have a lower threshold to accommodation than would a large multi-location regional office. So the limits to accommodation exist, and the other thing to keep in mind is it's very important that accommodation involves all parties. Involves the employer, involves the employee, and in some cases involves a union, if a union should be in place. So it's important to note, just as a wrap-up on this point, that there is a limit, and that limit is undue hardship. And when an employer has achieved and shown that they've reached the level of undue hardship, they've met their duty to accommodate. Lastly, I want to talk about a very important concept of accommodation involving a reasonable, not a perfect solution. And what I mean by that is if someone comes in and says, you know, due to my disability, I can no longer work evenings, that doesn't automatically mean that you put them on the day shift. It's very important in accommodation situations to think outside the box, to be creative, for both parties to come up with options to solve the issue. And it's very, very important that that employees understand that the burden doesn't just rest with employers. There seems to be this myth and perception out there that it's all the responsibility of the employer because they're management and they're the ones that have to come up with the options. But in fact, what we tell our clients on the Rodney Employment Law side is that you have to push your employees to come up with creative options, and they need to know at the end of the day, it's a reasonable, not a perfect solution. I want to wrap up today's session with a very important analogy. Suppose you're waiting, and this is probably the best way to explain accommodation in a nutshell. Suppose you're waiting for an elevator, and the elevator door opens, and there's 6 people in the elevator. You often ask yourself, should I go in and be squished and uncomfortable, or should I wait for the next elevator? When it comes to accommodation, this is what we say to our employer clients. In order to satisfy the duty to accommodate, you need to go into that elevator until it is very full, until you're feeling uncomfortable, until you're feeling squished. It's not supposed to be comfortable for you, and in some cases, not comfortable for the employee. So remember, when you're faced with accommodation issues in the future, to remember the elevator analogy and the importance of inconvenience and discomfort when you're going through the accommodation process. Thank you very much for listening to me today talk about the very important and delicate topic of workplace accommodation.